everyone in this room knows, these attacks are not just theoretical. We're already experiencing them, and they're already affecting our lives. So Tremer et al. In 2016 dealt with reconstructing models from behind machine learning APIs, and the response from the companies is something that we in the legal community actually find very interesting. The response from Big ML was that even if stealing software were easy, there's still an important disincentive to do so in that it violates intellectual property law. Well, as someone in the legal community, this caught my attention because this issue is actually far from settled. Our paper highlights the fact that the relationship between existing laws governing more traditional kinds of attack and machine learning attacks is, at this point, quite under-theorized and far from clear. Machine learning systems are vulnerable to types of attacks that are not clearly contemplated by our existing legal frameworks. In our paper, we review 4 different scenarios grounded in the adversarial machine learning literature to explore how these attacks interact with major areas of law currently governing cyber attack. We show that while some kinds of attacks are likely covered by existing law, though perhaps not perfectly, others are less likely to result in liability. So today, with all of you, I'm going to explore 2 questions. So first, is a poisoning attack a violation of the Computer Fraud and Abuse Act? And second, is model extraction or model stealing an instance of copyright infringement? In both cases, the answer, as I will sort of walk through with you, is far from clear. So, first. Different machine learning researchers have explored the effect of poisoning attacks, and Jagielski et al. In 2018 sort of explored the context of a healthcare data set consisting of patient dosage of the anticoagulant drug warfarin. They show that via a poisoning attack, 1/10 of the patients could have their dosages changed by 359%. If you know anything about warfarin, that is a really dangerous scenario. The precision with which those dosages are calculated is quite refined, and the consequences of incorrect dosages are very serious. So could this kind of attack be prosecuted under criminal computer anti-hacking statutes like the Computer Fraud and Abuse Act? So a little bit of background on the Computer Fraud and Abuse Act. It is in the US, it's the hallmark federal anti-hacking statute that we have. The funny thing about it is it was literally enacted as a result of the movie War Games. It was enacted in 1984, and it surprisingly has kept up with over 30 years of technological change. And in part, it has done so by having very broadly worded requirements and language. So to get back to the poisoning attack, the one described previously could plausibly be a violation of the Computer Fraud and Abuse Act. So simply stated, the CFAA, as I'm going to refer to it, broadly prohibits individuals from intentionally accessing computers without authorization, with exceeding authorized access on the computer, and causing damage to systems without authorization. Violators of these provisions may face lawsuits by the victims, as well as criminal prosecution by the state. US attorneys have successfully used the CFAA to prosecute a wide range of activities, and in fact, some would say too wide range of activities, thanks in large part to the broadly worded prohibitions. That said, adversarial ML might be quite different. So other legal scholars, most notably Kalo et al. In 2018, have pointed out that adversarial machine learning attacks present definitional challenges for our statutes. Much of this act is couched around whether access has occurred or a system has been damaged. And machine learning attacks that do neither don't really seem to fit within the logic of this statute. Sorry, my notes are messy. So, the strongest argument in the poisoning attack example is that it may be in carrying out the attack, the adversary transmitted code. So prosecutors could argue that the poisoned examples operate like a piece of code that creates damage to the model in a way that disrupts the system. However, this analysis becomes far less clear in cases where the purpose of the machine learning system is more open-ended. Take TAFE as an important example. When in principle do innocuous inputs become malicious? Where do we draw those lines in the law? And at what point does a machine learning system reach a state of being damaged? The CFAA is not necessarily well equipped to provide answers to such questions, nor may we want it to. The CFAA does plausibly cover some supply chain perturbation and poisoning attacks if the statutory language is interpreted in certain ways. But courts have struggled in similar cases in the past, and it's far from clear whether they can consistently resolve these issues in future cases. So moving on to model stealing, Tremé et al. In 2016 have reconstructed a model hosted behind a prediction API. They demonstrated that these attacks against the online services BigML and Amazon Machine Learning. This type of model stealing could have significant consequences for the business models of major ML companies. So are these types of model extraction attacks copyright infringements? So, spoiler, it's far from clear that this would actually result in copyright infringement claims. Copyright for software is an interest in code as a literary work, not for its functions.
Your slides aren't going ahead. I don't know if you
it's coming.
Okay.
So why do we think of code as a literary work instead of its function? Well, when copyright first started dealing with code, it kind of was literary works. So the issue here is that although code that runs a particular machine learning model might be protected by copyright, a reconstruction is unlikely to share the particular expression of code with the original. This reconstruction is therefore unlikely to violate copyright law. For instance, even if both the original and the stolen model are decision trees, as shown in Tremé et al., their exact implementation may differ, and thus the stolen model would not necessarily infringe a copyright. It is possible in some circumstances that machine learning models may qualify as trade secrets, but this is a very different standard than the law. Trade secret law could protect a model against reconstruction, but in order to successfully sue for trade secret disclosure, an owner has to show that they took reasonable precautions to prevent that disclosure. So this places an affirmative burden on the provider of the original model. So in the absence of intellectual property protection, one potential way to prevent model stealing would be to include a terms of service that specifically prohibits this type of interaction with the model. That would establish a contract with any of the API users. However, contractual agreements only create rights against the users with whom you've entered into that contract. These types of solutions don't help if an adversary releases a reconstructed model publicly. In any case, model extraction, as well as model inversion, as discussed further in our paper, are attacks where existing law might not protect machine learning systems in the way that companies or researchers might expect. So in the 2017 Supreme Court decision, Packingham versus North Carolina, Justice Kennedy wrote, "The forces and directions of the internet are so new, so protean, and so far-reaching that courts must be conscious that what they say today might be obsolete tomorrow." I just want to pause here because the internet has been around for 30 years, and the courts are interacting with it as if it's this like scary new thing that they've never had to think about before. And I just sort of want to throw this out here as a little bit of a cautionary tale or sort of a cautionary message. One way to make courts conscious of these issues and avoid bad law is to actively engage lawyers and machine learning security researchers together to help build standards that make sense before these issues land in a courtroom. Machine learning is already being widely used in real-world applications, and the scope and stakes of those applications will only grow. We're not certain how this is going to come out in the courts and in the case law, but what we've learned as a legal community is when we make law based on one use case that sort of we actively think we want to protect against, we often create significant ramifications for dual use or multi-use technologies, particularly in the context of preserving and protecting civil liberties. So how adversarial machine learning attacks are dealt with by the law, how we assign blame, how we deter behavior, how we create and enforce the boundaries between permissible and impermissible interactions with these systems will have important implications for how we collectively deal with the consequences of these attacks. But to do so, we have to make efforts now to bring machine learning researchers and practitioners and lawyers together to carefully consider how our current laws map onto these new scenarios, how they fall short, and together imagine how both designing machine learning systems and in designing our laws, we can provide robust responses to these adversarial attacks and the risks they pose, while also honoring and preserving space for dual uses, particularly the exercise of civil liberties. Thank you.